Another bill we have is House Bill 1, the Forfeiture bill. Remember that was last year, much discussion and time spent with that document and that bill. We had, I think, a good ongoing discussion after the session was over. The Speaker set up a study group made up of the several members of the House, several members representing the prosecuting attorneys and DAs of the state, and also some sheriffs. And we met in this room, I think, 3 times, if I recall correctly, and at those meetings went through reviewing the bill, concerns that the prosecuting attorneys had, problems the sheriff had. And we've tried to address those problems in a redraft of the bill that will be published today as a conclusion of this meeting. The bill itself is, again, a product of the work of this workforce that the Speaker set up, and we will have also further input from the members of the committee as it proceeds. I'm going to first put that into a subcommittee, and I'm going to assign that to the Jacob subcommittee. Did you have it last year, Ms. Jacobs? So we'll continue. That's what I thought we were doing. Have it continue with his committee for further hearings. I'll give, anyone here representing the Sheriff's Association? Apparently not, but we had the sheriffs sitting in with us, and they gave some very good position concerns they had, and one of the things that they really felt very strong about, I believe, is the need to have in the law specific language that addresses what is permissible in the use of forfeiture funds. And I think also the DAs had, prosecuting attorneys had some concerns in that area. So we tried to address that, as well as an appropriate means of having accountability. And the accountability will be through the law enforcement agencies and the DAs. The information will be put into a depository with the Carl Vinson Institute, and Carl Vinson Institute will hopefully work with us on preparing what will be the documents to be used, because they'll have the software as far as their systems. And so these are things we want to get ironed out and have certainty before we have the bill proceed out of our committee. Any other questions from anyone in the audience, comments?
Mr. Chairman, Mike Klein at the Georgia Public Policy Foundation. Could you summarize for us the changes and revisions in the HB1 substitute?
I'll give you a brief overview of it. Through the committees that we held, the meetings we held, I'll try and remember the top subjects that were discussed. There was a limitation dollar-wise as to when there would be what we call a non-judicial forfeiture or foreclosure type action. We had recommended the bill earlier to be at $25,000, and that was after discussions with the prosecuting attorneys. They had some concerns about it. I appreciate their concerns, and we've changed that to leave it where it is now at $5,000, with the understanding that as they recognize, we want to be sure that anyone who has a interest in that and who comes forward and says, that's my property, it should not be taken through a seizure and foreclosure, whatever reason, there will be going from that concern to a judicial foreclosure. Correct, Mr. Banner?
I think that's backwards, Mr. Chairman. It was 25, we recommended 5, and it's staying at 25.
I'm sorry, you're right, it is back. Excuse me. We were recommending dropping from 25 to 5, thank you. And instead, we'll leave it 25, but if somebody does come in and expresses they feel that their interest in that property is being taken, and they challenge the question of whether or not it should be appropriate to be going through forfeiture, there will be a judicial action filed to have a judge look at it and make that determination. So that's the one thing. The second thing was the issue we had in the concerns about a probable cause versus clear and convincing evidence as a standard of evidence to be determining the evidence before the court as to whether or not the state has met that burden. And we were recommending clear and convincing evidence as the standard. We've agreed to come back to the probable cause standard and not use clear and convincing. So those are two major things. The third thing dealt with
creating an objective standard, Mr. Chairman, for the innocent owner provision.
right. And that was the other part of it we wanted to get into. Those are major things. The rest of it dealt with a lot of but I mentioned the concerns the sheriff's expressed about it. We hope that we have answered that concern by having very clear language as to defining what they can use the money for. Also, they said they wanted to have a very straightforward provision as to the filing of their reports. There's always been some cloudiness there as to who had that responsibility, whether it was a duty of the law enforcement agency or a duty of the local government, city or county, and we felt that the appropriate responsibility should rest with the law enforcement agency that receives the money and has the responsibility of oversight and use of those monies. So that is where the clearly drawn lines are now. There will be requirements, as with the prosecuting attorneys and the DAs, to make their own filings to cover the use of the funds, but also with the prosecuting attorneys, we've outlined specific things that the money can be used for, which they wanted to have in there. So those are major things that we looked at.